In this subunit, we'll talk about our final formation defense, the defense of unconscionability. All right, in this unit, we've been talking about formation defenses, and there are all of our formation defenses listed there. Earlier, we talked about duress, misrepresentation, incapacity, and undue influence. And we just finished talking about illegality and public policy. Now let's talk about contracts that are unenforceable because they are unconscionable. All right, let's take a little time to set up the doctrine of unconscionability. This is either the easiest doctrine you're going to learn in contracts class, or it is the most difficult doctrine you're going to learn in contracts class. Why? Well, because it's really all about whether this contract is so unfair that a court will refuse to enforce it. Now, you can either look at that and say, okay, now I have free rein to talk about fairness, which is a legitimate approach, or you're going to struggle and say, listen, I can't quite get a grasp on when a court will say a contract is unconscionable. If you say that, then you're like me. I struggle with this all the time. How can I predict when a court will say that this contract is unenforceable because it's just so unconscionable? If it helps, courts say, you know, a contract is unenforceable because it shocks the conscience of the court. So it's not just about it being unequal or a little unfair. It has to be so unfair that it shocks the conscience of the court. It's a better standard than just saying unfair, but it's still not a really good standard to get a grasp on. Here's a caution. Don't go hog wild arguing that a contract is unconscionable. I think the courts reserve it for only the most onerous cases. This is the reasoning. Parties are in the best position to determine whether this contract is in their best interests. How can a court come in later and now say this contract is not in the best interest of the parties? Now, you might say, well, you have one party who now is coming to court and arguing that the court should be unenforceable because it is not in my best interest and it is so unfair. Is this party arguing that just because they regret the decision? If we let parties get out of contracts, if we let parties escape their contractual obligations simply because they regret entering into the contract, that will undermine contract obligations. So keep that in mind as we go through this unit, this subunit on unconscionability. All right, let's continue our discussion on unconscionability. What should your approach be? Well, here's what I think about unconscionability. I think it's a stink test. I think if the court just looks at it and it stinks to the court will say this contract is unenforceable because it's unconscionable. But what I like to do is I like to think of it as a contract that falls between the cracks of the other defenses. So remember our other defenses: incapacity, misrepresentation, duress, and undue influence, right? For incapacity, you had to have someone who is either under 18 years old, who was a minor, or was suffering from some sort of mental infirmity or mental defect. So in the unconscionable situation, we might look for the case that just falls outside of that. So we have a particularly gullible plaintiff, or we have a very unsophisticated plaintiff. They're not a minor, and they're not suffering from some sort of mental infirmity that would rise to the level of an incapacity defense. So look for that. Misrepresentation. Remember, in misrepresentation, we have to have some sort of statement that's not in accord with the facts, right? But what if some statements are not really lies or fraudulent or misrepresentations, but they're misleading, or the contract, the language of the contract is confusing? In that case, we don't have a case of misrepresentation, but we might have a case for unconscionability. We also talked about duress, and in duress, you need a threat. Someone has to threaten the other party, and that threat has to be improper and has to induce the other party, the aggrieved party, to enter into the contract. What if we don't have a threat from the contracting party? We just have a case where the aggrieved party is under a tremendous amount of economic duress, and the other party uses that to her advantage, right? We don't have a case of duress in that situation, but this type of case might be ripe for an unconscionability argument. And finally, we have undue influence, and we have in undue influence a relationship of trust or dominance. But what if we don't have that relationship in our fact pattern? What if it's just a relationship between a consumer and a seller, and we don't have any type of relationship of trust or dominance, but we do have unequal bargaining power, and we might have the seller who has a contract of adhesion or something like that? In that case, we don't have a case for undue influence, but you might have a good argument for unconscionability. Here's another tip. If your fact pattern allows you to argue incapacity, misrepresentation, duress, or undue influence, don't argue unconscionability. Unconscionability should be the last place you go. Unconscionability is the defense of last resort. I don't have any of the other defenses, so now I just have to simply argue that this contract is so unfair that it should shock the conscience of the court, and the court should not enforce it. Go to your other defenses first. They are much better than the unconscionability defense. All right, so I said the unconscionability doctrine is a stink test, but the courts do use a rubric or standards to look at the fact pattern. So here's the law with respect to unconscionability. For a court to declare a contract unconscionable, there must be both procedural unconscionability and substantive unconscionability. What is procedural unconscionability? Well, procedural unconscionability just means that the formation process, the contracting process, was flawed in some way. What is substantive unconscionability? Substantive unconscionability is that the terms of the contract are just unfair, one-sided, so unequal that it shocks the conscience of the court. So what am I looking for if I'm looking for procedural unconscionability? Remember, procedural unconscionability is about how the parties entered into the contract. Well, I'm looking for maybe fine print in the contract that a person wouldn't see, or some sort of convoluted language that only the most experienced lawyer would understand, or maybe even a lawyer can't understand it. Or maybe we have an unsophisticated party, or the party, one of the parties, the party that is not seeking to have the contract declared unenforceable, engage in some sort of misleading tactics or something like that. That's what we're looking for in procedural unconscionability. What are we looking for in substantive unconscionability? Well, some sort of contract price that grossly exceeds the market price. If the contract is really one-sided, if there's something in the contract that we don't expect to see in that contract, and so it will result in unfair surprise for the aggrieved party, or maybe there's hidden in language, right? The hidden part, that's procedural unconscionability. Maybe there's language in the contract that limits remedies, and we just look at that and say, wow, reading this contract, if the other party breaches, you have no remedies, and that's not something we would expect in a contract. Or maybe the choice of law is just so way out there, so it's a contract between a party in New York and a consumer in Wisconsin, and they choose Turkish law for some reason, and Turkish law has this strange provision that is very one-sided for one of the parties. Maybe that's substantively unconscionable. Look for things. Once again, it's a stink test. This should be your last argument, but if you're going to make it, if you're going to do an analysis of unconscionability, you have to look for both procedural unconscionability and substantive unconscionability.